We continue with property. This time we cover Articles 440 to 475 of the new Civil Code. Right of accession. Article 440. The ownership of property gives the right by accession to everything which is produced thereby, or which is incorporated or attached thereto, either naturally or artificially. Accession is the right of a property owner to everything which is produced thereby, or accession discreta, or which is incorporated or attached thereto, either naturally or artificially, known as accession continua or accession non interrompida. Accession continua or accession non interrompida is divided into two: natural accession and artificial accession. Classification of accession. Accession can be accession discreta, which refers to the fruits, or accession continua, which refers to the attachment or incorporation. Accession discreta refers to the natural fruits, industrial fruits, and civil fruits, while accession continua refers to the real property or to the personal property that is attached or incorporated into the thing. Reason behind accession. For accession discreta, justice pure and simple, for one who owns a thing should justly enjoy its fruits, and for accession continua, economic convenience is better attained in a state of single ownership than in a co-ownership. Moreover, natural justice demands that the owner of the principal or more important thing should also own the accessory. Right of accession with respect to what is produced by property. Article 441. To the owner belongs 1. The natural fruits, 2. The industrial fruits, and 3. The civil fruits. This article refers to accession discreta, which is defined as the right to the ownership of fruits produced by our property. Under this article, the owner of the land owns the fruits. In the following cases, however, it is not the owner of the land who owns the fruits, but somebody else. 1. The possessor in good faith of the land. He owns the fruits already received. 2. The usufructuary in a contract of usufruct. 3. The lessee gets the fruits of the land, but of course the owner gets the civil fruits in the form of rentals. And 4. In a contract of antichresis, the creditor gets the fruits, although of course said fruit should be applied first to the interest, if any is owing, and then to the principal amount of the loan. Article 442. Natural fruits are the spontaneous products of the soil, and the young and other products of animals. Industrial fruits are those produced by lands of any kind through cultivation or labor. Civil fruits are the rents of buildings, the price of leases of lands and other property, and the amount of perpetual or life annuities or other similar income. In one case, the Supreme Court held that the term natural, industrial, and civil fruits, as defined by the Code, are highly technical, and therefore, when they are found in a final judgment, there can be no doubt as to their meaning. Thus, if a final judgment speaks only of natural and civil fruits, it is understood that industrial fruits are not included. Natural fruits are of two kinds: the spontaneous products of the soil, that is, human labor does not intervene, and the young and other products of animals. In spontaneous products of the soil, examples are herbs, common grass, and the young and other products of animals, example, chicks and chicken eggs. Industrial fruits are those produced by lands of any kind through cultivation or labor. Examples are lanzones and bananas, palay and corn, zacate, which is cultivated as food for horses, and all kinds of cultivated vegetables, since these are no doubt also produced by the land through human labor. Article 443. He who receives the fruits has the obligation to pay the expenses made by a third person in their production, gathering, and preservation. Characteristic of the expenses referred to in Article 443. 1. They must have been used for production, gathering, or preservation, not for the improvement of the property. And 2. They must have been necessary and not luxurious or excessive. Indeed, they must be commensurate with those ordinarily necessitated by the product. Question. Suppose the expenses exceed the value of the fruits, as when, for example, typhoons have damaged the crops. Must there still be reimbursement for the expenses? Answer. Yes, if the owner insists on being entitled to the fruits. This is because, number 1, the law makes no distinction or exception. Number 2, the same thing would have happened had the owner been also the planter. And number 3, he who gets expected advantages must be prepared to shoulder losses. It is understood, of course, that if the fruits had not yet been gathered, no indemnity is required. Article 444. Only such as are manifest or born are considered as natural or industrial fruits. With respect to animals, it is sufficient that they are in the womb of the mother, although unborn. There are two kinds of crops, annual and perennial. Annual crops, like cereals, grains, rice, corn, and sugar, are deemed manifest or existing the moment their seedlings appear from the ground, although the grains have not yet actually appeared. Meanwhile, perennial crops like oranges, apples, mangoes, and coconuts are deemed to exist only when they actually appear on the trees. As to animals, the young of animals are already considered existing even if still in the maternal womb. Right of accession with respect to immovable property. Article 445. Whatever is built, planted or sown on the land of another, and the improvements or repairs made thereon, belong to the owner of the land, subject to the provisions of the following articles. Article 445 deals with accession continua, more specifically with accession industrial or building, planting, and sowing. This article can be applied only if the owner of the land is known. If he be unknown, no decision on the ownership of the things planted, built, or sown can be made. Basic principles of accession continua or accession industrial. Number 1, to the owner of the principal, the land for example, must belong also the accessions in accordance with the principle that the accessory follows the principal. Number 2, the union or incorporation must, with certain exceptions, be effected in such a manner that to separate the principal from the accessory would result in substantial injury to either. Number 3, he who is in good faith may be held responsible, but he should not be penalized. Number 4, he who is in bad faith may be penalized. Number 5, no one should enrich himself unjustly at the expense of another. And number 6, bad faith of one party neutralizes the bad faith of the other, so both should be considered in good faith. Article 446. All works, sowing and planting, are presumed made by the owner and at his expense, unless the contrary is proved. The two disputable presumptions under this article are, number 1, the works, sowing and planting were made by the owner, and number 2, they were made at the owner's expense. Example, I own a piece of land containing rice crops and a fence. It is presumed that I made the plantings and the fence at my expense. This presumption is, however, rebuttable, as the contrary may be proved according to the law. The usefulness of the presumption lies in the fact that I do not have to prove anymore that they were constructed at my expense, since I have the presumption in my favor. Whoever alleges the contrary should prove his contention. Article 447. The owner of the land who makes thereon, personally or through another, plantings, constructions, or works with the materials of another, shall pay their value, and if he acted in bad faith, he shall also be obliged to the reparation of damages. The owner of the materials shall have the right to remove them only in case he can do so without injury to the work constructed, or without the plantings, constructions, or work being destroyed. However, if the landowner acted in bad faith, the owner of the materials may remove them in any event with a right to be indemnified for damages. This article treats of the rights and obligations of number 1, the owner of the land who uses the materials of another, and number 2, the owner of the materials. Rights and obligations of the owner of the land who uses the materials of another. Number 1, if the landowner acted in good faith, he becomes the owner of the materials, but he must pay for their value. The only exception is when they can be removed without destruction to the work made or to the plants. In such case, the owner of the materials can remove them. Number 2, if the landowner is in bad faith, he becomes the owner of the materials, but he must pay their value and damages. The exception is when the owner of the materials decides to remove them, whether or not destruction would be caused. In this case, the materials would still belong to the owner of said materials, who in addition will still be entitled to damages. Rights and obligations of the owner of the materials. Number 1, if the landowner acted in good faith, the owner of the materials is entitled to reimbursement provided he does not remove them, and he is entitled to removal provided no substantial injury is caused. Number 2, if the landowner acted in bad faith, the owner of the materials is entitled to the absolute right of removal and damages, whether or not substantial injury is caused, and he is entitled to reimbursement and damages in case he chooses not to remove them. Article 448. The owner of the land on which anything has been built, sown, or planted in good faith shall have the right to appropriate as his own the works, sowing, or planting after payment of the indemnity provided for in Articles 546 and 548, or to oblige the one who built or planted to pay the price of the land, and the one who sowed the proper rent. However, the builder or planter cannot be obliged to buy the land if its value is considerably more than that of the building or trees. In such case, he shall pay reasonable rent if the owner of the land does not choose to appropriate the building or trees after proper indemnity. The parties shall agree upon the terms of the lease, and in case of disagreement, the court shall fix the terms thereof. However, the builder or planter cannot be obliged to buy the land if its value is considerably more than that of the building or trees. In such case, he shall pay reasonable rent if the owner of the land does not choose to appropriate the building or trees after proper indemnity. The parties shall agree upon the terms of the lease, and in case of disagreement, the court shall fix the terms thereof. Clearly, Article 448 applies only when the builder, planter, or sower believes he has the right to so build, plant, or sow because he thinks he owns the land or believes himself to have a claim of title. Article 449. He who builds, plants, or sows in bad faith on the land of another loses what is built, planted, or sown without right to indemnity. Article 450. The owner of the land on which anything has been built, planted, or sown in bad faith may demand the demolition of the work or that the planting or sowing be removed in order to replace things in their former condition at the expense of the person who built, planted, or sowed. Or he may compel the builder or planter to pay the price of the land and the sower the proper rent. Article 451. In the cases of the two preceding articles, the landowner is entitled to damages from the builder, planter, or sower. The preceding articles, Article 449, 450, and 451, pertain to the rights of a landowner if the builder, planter, or sower is in bad faith. Example: if B builds in bad faith a house on the land of A being in good faith, What are the three alternative rights of A? Answer. A is allowed to, number 1, get the house without paying any indemnity for its value or expenses, but with the obligation to pay under Article 452 necessary expenses for the preservation not of the house but of the land, plus damages. 2. Demand the demolition of the house at the builder's expense plus damages. Or 3. Compel the builder to buy the land whether or not the value of the land is considerably more than that of the value of the house plus damages. Article 452. The builder, planter, or sower in bad faith is entitled to reimbursement for the necessary expenses of preservation of the land. Article 453. If there was bad faith, not only on the part of the person who built, planted, or sowed on the land of another, but also on the part of the owner of such land, the rights of one and the other shall be the same as though both had acted in good faith. It is understood that there is bad faith on the part of the landowner whenever the act was done with his knowledge and without opposition on his part. Definition of bad faith. The landowner is considered in bad faith whenever the act was done with his knowledge and without opposition on his part. A person who buys land knowing that a construction had been made thereon by a person other than the owner and who pays only for the land and not for the construction is in the same category as a landowner who has acted in bad faith. Bad faith on the part of the builder, planter, or sower is not expressly defined in the law, but by analogy we may say that the building, planting, or sowing made knowingly by one on a land not belonging to him and without authority is done in bad faith. Article 454. When the landowner acted in bad faith and the builder, planter, or sower proceeded in good faith, the provisions of Article 447 shall apply. Article 455. If the materials, plants, or seeds belong to a third person who has not acted in bad faith, the owner of the land shall answer subsidiarily for their value and only in the event that the one who made use of them has no property with which to pay. This provision shall not apply if the owner makes use of the rights granted by Article 450. If the owner of the materials, plants, or seeds has been paid by the builder, planter, or sower, the latter may demand from the landowner the value of the materials and labor. In this article, three people are involved: the landowner, the builder or planter or sower, and the owner of the materials. The rights of the first two remain unaffected, their rights being established by the preceding articles. The important thing under this article is the discussion of the rights of the owner of the materials. If the owner of the materials acted in bad faith, he loses all rights to be indemnified. Moreover, he can even be liable for consequential damages, as when the materials are of an inferior quality. However, if the owner of the materials acted in good faith, he is entitled to reimbursement from the builder or planter or sower, principally, since it was the builder or planter or sower who first made use of the materials. In case of insolvency on the part of the builder, the landowner is subsidiarily liable if he makes use of the materials. If all the three parties are in bad faith, all must be considered to have acted in good faith. Problem: Pedro in bad faith constructs a house with the materials of Jose, who is also in bad faith, on the land of Tomas, who is in good faith. Give their rights and obligations. Answer: Since both Pedro and Jose are in bad faith, as between them good faith must govern. Hence, Jose, the owner of the materials, must be reimbursed by Pedro, but in case Pedro cannot pay, Tomas, the landowner, will not be subsidiarily liable because as to him, Jose is in bad faith. If Pedro pays, Pedro cannot ask reimbursement from Tomas because as to Tomas, Pedro is in bad faith. Note that the law says if the owner of the materials, plants, or seeds has been paid by the builder, planter, or sower, The latter may demand from the landowner the value of the materials and labor. It should be understood, however, that this reimbursement may be had only if the landowner profits by the accession and not when he does not choose to appropriate the construction or planting for himself.
Article 456. In the cases regulated in the preceding articles, good faith does not necessarily exclude negligence, which gives right to damages under Article 2176.
It is possible that a person may be in good faith and also negligent. In fact, in negligence, there is no intent to do wrong. On the other hand, bad faith presupposes an intent to cause damage or prejudice. In case there is negligence, damages for his culpa will arise under Article 2176. Article 2176 says, whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delict or culpa achilleana and is governed by the provisions of this chapter.
Article 457. To the owners of lands adjoining the banks of rivers belong the accretion which they gradually receive from the effects of the current of the waters.
With this article begins accession natural, the principal forms of which are 1. Alluvium, 2. Avulsion, 3. Chains of course of rivers, and 4. Formation of islands. Alluvium or alluvio is the soil deposited or added to the lands adjoining the banks of rivers and gradually received as an effect of the current of the waters. Accretion is the process whereby the soil is deposited, while alluvium is the soil deposited on the estate fronting the river bank. The owner of such estate is the riparian owner. Accretion is a broader term because alluvium, strictly speaking, applies only to the soil deposited on river banks. It is possible that the soil deposit be made also on the banks of lakes. In this case, although it is an accretion, it is not called alluvium, although the rule as to ownership is the same. Based on decided cases, the following are the essential requisites of alluvium. 1. The deposit should be gradual and imperceptible as a process. 2. Cause is the current of the river and not due to works expressly designed for the purpose. 3. Current must be that of a river. If a lake, the Spanish law of waters must apply. 4. The river must continue to exist. And 5. The increase must be comparatively little and not, for example, such as would increase the area of the riparian landowner by 150%. Again, based on decided cases, the following are the reasons why alluvium is granted to the riparian owner. 1. To compensate him for the loss he may suffer due to erosion or the destructive force of the water and danger from floods. 2. To compensate him because the property is subject to encumbrances and legal easements. 3. The interests of agriculture require that the soil be given to the person who is in the best position to cultivate the same. And 4. Since after all it cannot be said with certainty from whom the soil came, it may just as well be logically given to him who can best utilize the property.
Article 458. The owners of estates adjoining ponds or lagoons do not acquire the land left dry by the natural decrease of the waters or lose that inundated by them in extraordinary floods.
Article 458 applies when the estate adjoins a pond or a lagoon. It does not apply when the estate adjoins a lake, a river, a creek, or other streams. In such a case, the land left uncovered reverts to the adjoining estate which owned it at the very beginning.
Article 459. Whenever the current of a river, creek, or torrent segregates from an estate on its bank a known portion of land and transfers it to another estate, the owner of the land to which the segregated portion belonged retains the ownership of it, provided that he removes the same within 2 years.
This article treats of avulsion. Avulsion is the process whereby the current of a river, creek, or torrent segregates from an estate on its bank a known portion of land and transfer it to another estate. Another definition is that avulsion is the removal of a considerable quantity of earth upon or annexation to the land of another suddenly and by the perceptible action of the water. Question. A and B owned lands fronting a river. Through the force of the current, an identifiable portion of B's estate was suddenly transferred to A's land. Who owns said portions? Answer. B. The original owner, since this is a case of avulsion.
Article 460. Trees uprooted and carried away by the current of the waters belong to the owner of the land upon which they may be cast, if the owners do not claim them within 6 months. If such owners claim them, they shall pay the expenses incurred in gathering them or putting them in a safe place.
Question. Because of the force of the river current, some trees on the estate of A were uprooted and cast on the estate of B. Who owns the trees? Answer. A should still be considered as the owner of the uprooted trees, but if he does not claim them within 6 months, B will become the owner. If A makes the claim, he will have to shoulder the expenses for gathering or putting them in a safe place. Failure to make the claim within 6 months will bar any future action to recover the trees. In the example given, even if the trees have been transplanted by the owner of the land upon which they have been cast on his own land, ownership still pertains to the person who lost the trees, provided that the claim was made properly. Incidentally, the owner of the land upon which the trees have been cast does not have to wait for 6 months before he can temporarily set them aside to make proper use of his own land. Must owner of land upon which the uprooted trees have been cast be given compensation? It depends. If he has incurred expenses for preserving them, as when he gathered them in a safe place for eventual return, or when he transplants them only for preservation purposes, he is doubtless entitled to indemnification. If he has done nothing, however, he cannot demand indemnification, unless, of course, he has suffered in any way, and the real owner has benefited in that, for example, they were not carried away by the current.
Article 461. Riverbeds which are abandoned through the natural change in the course of the waters ipso facto belong to the owners whose lands are occupied by the new course in proportion to the area lost. However, the owners of the lands adjoining the old bed shall have the right to acquire the same by paying the value thereof, which value shall not exceed the value of the area occupied by the new bed.
Example, Jose's and Maria's estates face each other and adjoin a river. Later, the river naturally changes its course and the riverbed is abandoned. The new riverbed happens to be in the land of Maximo. Who owns the abandoned riverbed? Answer. Maximo owns the entire abandoned riverbed to compensate him for the loss of the land now occupied by the new riverbed. Here is a bar question on the matter. A and B each own a parcel of land on opposite sides of a river. The river changed its course and passed through the land of D, not adjoining either A or B. As a result of the change of course, D lost 10 hectares of land. Assuming that the area of the abandoned riverbed between the lands of A and B is also 10 hectares, who is entitled to the accession and why? Answer, D in view of his loss. Based on decided cases, the following are the requisites for Article 461 to apply. 1. The change must be sudden in order that the old riverbed may be identified. 2. The changing of the course must be more or less permanent. 3. The change of the riverbed must be a natural one, namely caused by natural forces. 4. There must be a definite abandonment by the government. And 5, the river must continue to exist.
Article 462. Whenever a river, changing its course by natural causes, opens a new bed through a private estate, this bed shall become a public dominion.
Under this article, even if the new bed is on private property, the bed becomes property of the public dominion, just as the old bed had been of public dominion before the abandonment.
Article 463. Whenever the current of a river divides itself into branches, leaving a piece of land or part thereof isolated, the owner of the land retains his ownership. He also retains it if a portion of land is separated from the estate by the current.
Example, the estate of A adjoins a river, but the river divides itself into branches, thus affecting the property of A. A, however, remains the owner of the portion, this time an island, which, number 1, may be isolated from the rest, and number 2, may be separated from the rest. This article applies whether the river is navigable or not, for in both cases, the owner should not be deprived of his dominion over the segregated or isolated property.
Article 464. Islands which may be formed on the seas within the jurisdiction of the Philippines, on lakes, and on navigable or floatable rivers belong to the state. Article 465. Islands which, through successive accumulation of alluvial deposits, are formed in non-navigable and non-floatable rivers, belong to the owners of the margins or banks nearest to each of them, or to the owners of both margins if the island is in the middle of the river, in which case it shall be divided longitudinally in halves. If a single island thus formed be more distant from one margin than from the other, the owner of the nearer margin shall be the sole owner thereof.
This article pertains to the ownership of islands. Question: who owns the island formed by unidentifiable accumulated deposits? Answer: it depends. 1. If formed on the sea, within the territorial waters or maritime zone or jurisdiction of the Philippines, the island is owned by the state. But if it is formed outside of our territorial jurisdiction, the island belongs to the first country to effectively occupy the same. Number 2, if the island is formed on lakes or navigable or floatable rivers, the island belongs to the state. Number 3, if the island is formed on non-navigable or non-floatable rivers, if nearer in margin to one bank, the owner of the nearer margin is the sole owner. But if equidistant, the island shall be divided longitudinally in halves, each bank getting one half.
Right of accession with respect to movable property.
Article 466. Whenever two movable things belonging to different owners are, without bad faith, united in such a way that they form a single object, the owner of the principal thing acquires the accessory, indemnifying the former owner thereof for its value. This article speaks of adjunction. Another name for adjunction is conjunction. Adjunction or conjunction is the process by virtue of which two movable things belonging to different owners are united in such a way that they form a single object. For example, A varnishes his table with the varnish of B. Problem: A, in good faith, uses the varnish of B in varnishing his table. What are their rights? Answer: A will become the owner of the varnish, in fact of the whole varnish table, but he must indemnify B for the value of the varnish.
Article 467. The principal thing, as between two things incorporated, is deemed to be that to which the other has been united as an ornament, or for its use or perfection. Article 468. If it cannot be determined by the rule given in the preceding article, which of the two things incorporated is the principal one, the thing of the greater value shall be so considered, and as between two things of equal value, that of the greater volume. In painting and sculpture, writings, printed matter, engraving, and lithographs, the board, metal, stone, canvas, paper, or parchment shall be deemed the accessory thing.
Test to determine which is the principal and which is the accessory. The principal is, number 1, that to which the other has been united as an ornament or for its use or perfection. 2, that of greater value. 3, that of greater volume. And 4, that which has greater merits from the combined consideration of utility and volume. In painting and sculpture, writings, printed matter, engraving, and lithographs, the board, metal, stone, canvas, paper, or parchment shall be deemed the accessory thing. This is because what has been written, printed, etc. is considered of greater importance.
Article 469. Whenever the things united can be separated without injury, their respective owners may demand their separation. Nevertheless, in case the thing united for the use, embellishment, or perfection of the other is much more precious than the principal thing, the owner of the former may demand its separation even though the thing to which it has been incorporated may suffer some injury.
In the second paragraph of the article, separation, although with injury, is allowed if the thing united for the use, embellishment, or perfection of the other is much more precious than the principal. Example, when a valuable diamond is set in good faith on a silver ring, the owner of the diamond can ask for separation even though there will be injury to the ring. Expenses for the separation must of course be borne by the person who caused the union, considering that both parties are in good faith.
Article 470. Whenever the owner of the accessory thing has made the incorporation in bad faith, he shall lose the thing incorporated and shall have the obligation to indemnify the owner of the principal thing for the damages he may have suffered. If the one who has acted in bad faith is the owner of the principal thing, the owner of the accessory thing shall have a right to choose between the former paying him its value or that the thing belonging to him be separated, even though for this purpose it be necessary to destroy the principal thing. And in both cases, furthermore, there shall be indemnity for damages. If either one of the owners has made the incorporation with the knowledge and without the objection of the other, their respective rights shall be determined as to both acted in good faith. Article 471. Whenever the owner of the material employed without his consent has a right to an indemnity, he may demand that this consist in the delivery of a thing equal in kind and value, and in all other respects to that employed, or else in the price thereof, according to expert appraisal. Article 472. If by the will of their owners two things of the same or different kinds are mixed, or if the mixture occurs by chance, and in the latter case the things are not separable without injury, its owner shall acquire a right proportional to the part belonging to him, bearing in mind the value of the things mixed or confused. Article 473. If by the will of only one owner, but in good faith, two things of the same or different kinds are mixed or confused, the rights of the owners shall be determined by the provisions of the preceding article. If the one who caused the mixture or confusion acted in bad faith, he shall lose the thing belonging to him thus mixed or confused, besides being obliged to pay indemnity for the damages caused to the owner of the other thing with which his own was mixed. Article 474. One who in good faith employs the material of another in whole or in part in order to make a thing of a different kind shall appropriate the thing thus transformed as his own, indemnifying the owner of the material for its value. If the material is more precious than the transformed thing or is of more value, its owner may, at his option, appropriate the new thing to himself after first paying indemnity for the value of the work or demand indemnity for the material. If in the making of the thing bad faith intervened, the owner of the material shall have the right to appropriate the work to himself without paying anything to the maker, or to demand of the latter that he indemnify him for the value of the material and the damages he may have suffered. However, the owner of the material cannot appropriate the work in case the value of the latter, for artistic or scientific reasons, is considerably more than that of the material. Article 475. In the preceding articles, sentimental value shall be duly appreciated. This is the end of Part 4. Thank you.